Good day, Crime Talk aficionados. Well, there was a hearing in the Bryan Kohberger matter and a deadline. And apparently the defense has filed a motion saying who the real killer is. We have an update on the Kill3r trial. We have an update on the Sean Combs trial. Video captures everything, ladies and gentlemen. Why are people so dumb to commit crime on video? We have this day in legal history, our legal quote of the day, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below and hit that little bell for notifications of when we go live or put up new content. And yes, you can check us out on any of your favorite podcasting apps. Before we get started, let me remind you to go to crimetalksearch.com and sign up for that background subscription service today. When you do, you'll be able to do as many searches as you desire on anyone here in the United States, and you're going to get a report emailed to you literally while you wait. And it's going to have all types of information as detailed as somebody's telephone number, their email address, whether they have criminal history, their social media presence. Are they on one of those sex offender registries? Yes, everything you want to know about people coming into your life, whether it's somebody you're going to date, maybe it's the parents of the kids that are hanging around your kid, go check them out. CrimeTalkSearch.com. You're going to be happy that you did. Let's go ahead and open the record for Thursday, May 15th, 2025. And first, Bryan Kohberger has named an alternate suspect who he claims is the real killer of the 4 University of Idaho students. Now, in this big bombshell move, just weeks before he starts trial, that's right, we'll see what it actually is. Now, it's sealed, of course, and we're going to have a hearing. But the suspect of accused of the quadruple homicide turned to a courtroom today where Judge Hippler is expected to make a series of last-minute decisions that will shape the capital murder trial starting in August. Now, in an 11th hour move to save Kohberger from the firing squad, the defense took the explosive step to pointing the finger at another suspect. Now, who this suspect is and what evidence the defense has that could be necessarily tying this person into the brutal murders, well, it remains a mystery. Now, the judge ordered that the defense filings remain under seal, keeping it cloaked in secrecy until trial. Now, the defense team for Kohberger has previously revealed plans to argue he was framed and that 2 killers must have committed the shocking crime. Now, like I said, Judge Hippler gave Kohberger's a deadline of May 23rd to hand him whatever actual evidence you have that supports those allegations other than just making an allegation. He also ordered the defense to provide to the judge how it is you believe that you are going to offer this evidence and why is it even admissible at trial. The state will then have until June 6th to respond to the defense claims before the two sides battle it out in a hearing later that month. The judge will then rule on whether the jury can hear about this alternate suspect or not. Now, this move by the Kohberger defense team comes less than a week after new details emerged in this case, including the phone calls to family members after the murders, the chilling porn choices, and the disturbing online searches about the serial killer Ted Bundy. Kohberger is facing the death penalty if convicted of the brutal murders of Kaylee Goncalves, Madison Mogan, Xana Kernodle, and Ethan Chapin. Now, as part of the hearing, the judge could determine what final pieces of evidence the jurors will be able to see and hear to decide the fate of Bryan Kohberger. And among those final pieces of evidence still in play is the research paper intricately detailing a fictional crime scene about a woman being stabbed to death at a trailer park. Phone records and bank transactions for both the accused killer and some of the alleged victims, as well as surveillance footage from locations close to the crime scene, are also likely to be discussed. Now, the trial is expected to last about 3 months. And that does not include the sentencing phase if necessary. Who knows? Bryan Kohberger could be found not guilty at trial. Obviously, he's entitled to the presumption of innocence. The government hasn't presented any evidence at this point because the trial hasn't started, obviously, but he is given that presumption. Now, obviously, if presumption of innocence is overcome and Bryan Kohberger is convicted, he faces the death penalty. And following recent changes in the Idaho state law, could face a firing squad, which if he were convicted and if that were to take place, unless he waived all his appeals, could probably take another 2 to 3 decades before any execution ever took place, if at all. To date, 13 separate defense efforts to take the death penalty off the table have been denied by the judge, including one where they cited to this autism spectrum disorder diagnosis as a reason to block Kohberger from the capital punishment. The judge has also dealt a series of other blows to Kohberger's defense strategy in recent weeks, ruling that jurors can hear the 911 call made by the victim's surviving roommates and see their panicked texts after Mortensen saw the masked killer inside the home. Now, the judge has also ruled against Kohberger in allowing Mortensen to describe the man inside her home using the term bushy eyebrows. Jurors will also be able to see Kohberger's Amazon shopping history, which prosecutors say reveals that he bought, curiously enough, a CrimeTalk knife and sheath and a sharpener from Amazon back in March of 2022. A matching sheath was found next to Mogen's body, with DNA on the sheath being traced back to Kohberger. Now, of course, the murder weapon has never been found. And like I said, Kohberger's entitled to that presumption of innocence. It's going to be interesting. Now, alternate suspect evidence. Just to say we believe somebody else did it is not enough. Now, remember, the prosecution always has to prove identity, that it was, in fact, Bryan Kohberger, that it was him, not someone who looked like him, not someone using his identity, but it was, in fact, Bryan Kohberger that committed the crime. Now, unless there is a confession of a third party, unless you can prove that that person was at that house that night and basically had a K-bar as well, I guess, or some other instrumentality of death that could be used, would be consistent with the murders, the chances of the defense being able to actually present this evidence at trial is pretty unlikely. And even if the judge says, okay, I think there's some relevance here, I'll give you a little bit of leeway, then the defense has to be able to get that evidence into evidence and it not be hearsay evidence. There has to be some exception to the hearsay rule. And just to say somebody was in the vicinity or somebody was out walking their dog that particular evening, there's no indication that ties him to any other. Like I said, I've been doing this a long time, ladies and gentlemen. Tried alternate suspect numerous times. Normally, they are shot down. Very, very unlikely unless you've got some pretty clear smoking gun. It was kind of like, well, we could have charged this guy or we should have charged Bryan Kohberger and we'll just pick Bryan Kohberger, right? I'd be very surprised. Now, I haven't seen the evidence. We'll have to wait and see. I'm just telling you, don't lose any sleep at night thinking that this evidence is necessarily going to be presented to the jury. Now, there was some other business conducted at the pretrial hearing. Like I said, we talked about the alternate suspect perpetrators. And like I said, the judge was quite adamant that they need to provide support and reasoning as to why this information was even admissible. Now, the trial is scheduled to begin August 11th, and Hippler said he'll spend the pretrial hearing laying out what he expects of the upcoming trial. The judge says, I don't like surprises. Now, seating the jury in a high-profile case will be complicated, and questions for potential jurors are a big part of the pretrial hearing. Now, Hippler said the universe of jurors will be determined. Then they'll be given a scrambled number, starting with number 1, and those jurors will come in and fill out a questionnaire. Once we have enough jurors, we stop, he said. Hippler said the questionnaire will be kept confidential and are essentially attorneys' eyes only. Paralegals and investigators can't have access as long as they comply with the rules set by the court. And if Kohberger wants to see the questionnaires, it has to be in the presence of his attorney, and he can't have copies to take back to the jail. As the jurors are narrowed down, they'll come in groups for questioning in court. The victims' families will be allowed in court for that, and a small number of public seats will be available in the courtroom as well. However, the judge said that the process will not be live streamed because he doesn't want internet sleuths and others to try and figure out who the potential jurors are. They will only be identified by their scrambled number to protect their identity. Potential jurors will be questioned privately about sensitive information and about what they may know about the case. Judge Hippler plans to seat 20 people with the jury, 12 primary jurors, and 8 alternates. And both sides agree that some of the discussion about potential juror questionnaires would be done out of the public view, and the live stream of the pretrial hearing would be shut off. They're also going to discuss the evidence that will be used at trial and the witnesses who will testify for each side. The evidence includes a model for the King Road residence where the murders took place, and prosecutors had a small replica of the house built to show to the jury. The defense initially objected to that being allowed, but the judge agreed to allow that in the case. As it relates to public viewing, the judge determined that the trial proceedings would be streamed live via the court's current streaming method. Both the prosecution and the defense brought up safeguards concerning the identities of certain witnesses, and Judge Hippler said that public interest may outweigh some witnesses' desires to remain hidden. Judge Hippler did not rule on that, but said you'll have to really convince me, which is great, Judge. Absolutely great. In addition, Judge Hippler determined other victims, i.e. the two surviving roommates, would be able to request their identities to be protected from public viewing. I'm not sure why, since we already know their names. Anyway, Judge Hippler began by saying he would not tolerate arguments during opening statements, and any objections would more than likely be sustained. And the judge also told the prosecution and the defense to estimate how much time they need for opening statements. The judge told both sides he would be able to enter the well with permission, but must keep out of the personal space of the jurors. The judge said that if Kohberger is found guilty, the penalty phase of the trial would begin as soon as it can, ideally the next day. The jury would also stay sequestered. Judge Hippler also said the penalty for Kohberger's one burglary charge would take place separately, and first due to it being a lesser charge is in regards to the four murder charges. So there you go. That is the update on the Bryan Kohberger hearing today. And like I said, I'd be very surprised if, in fact, we get any alternate suspect testimony at trial. Next on the docket, the Karen Read trial. That's right. The retrial of Karen Read continued Thursday with the significant testimony from forensic experts as well as the medical examiner. Dr. Irini Scorti-Bello shedded light on the circumstances surrounding the death of John O'Keefe. Now, the court session, presided over by the judge, obviously included detailed discussions of autopsy findings, evidence collection, and the condition of O'Keefe's body, with jurors paying close attention to graphic images and expert analysis. Now, the day began at approximately 9:10 this morning with a sidebar involving legal counsel, followed by the resumption of testimony from Maureen Harnett, a forensic scientist at the Massachusetts State Police Crime Lab. Now, Harnett, who testified on Wednesday, continued answering questions from the defense, Robert Alessi, about evidence collected from Karen Read's SUV, including its taillight and items such as O'Keefe's t-shirt and hoodie. She confirmed that the scrapings from the clothes were collected using a metal spatula-like device, with debris from two items coming and not separated. Now, Harnett also noted that the evidence bag containing these items was marked as collected by Massachusetts State Police Trooper Michael Proctor, who was the lead investigator. Now, during redirect, Special Prosecutor Hank Brennan re-questioned Harnett about blood evidence stored in the red Solo cups, an unusual method that prompted a defense objection. Harnett clarified that she was unaware of the specific contents of the cups and the challenges faced by investigators at the scene. Now, Alessi's questions appear to focus on the chain of custody, emphasizing that Harnett could only confirm the integrity of the items she personally submitted to the lab, such as swabs from the Solo cup and the drinking glasses. According to people that are at the trial, the jurors were highly engaged during Harnett's testimony, particularly when discussing O'Keefe's clothing. Harnett concluded her testimony about 9:55 after a brief attempt to correct a prior statement, which was halted and then followed by a sidebar. Well, at approximately 10 o'clock, then Dr. Irini Scorti-Bello, a medical examiner with the Commonwealth of Massachusetts since 2016, took the stand. She confirmed performing O'Keefe's autopsy on January 31st, 2022, and described the process, which included external and internal examinations and toxicology analysis. Scorti-Bello noted that her office is independent of the state police and the district attorney's office, though law enforcement observers are permitted at autopsies. She recalled two individuals present during O'Keefe's autopsy, though their names were not documented in her testimony or her notes. Now, Scorti-Bello detailed O'Keefe's injuries, supported by autopsy photos shown in court, which the judge cautioned jurors might be graphic. Of course they are. It's a homicide case. Anyway, the injuries included 1 centimeter laceration on O'Keefe's right upper eyelid, abrasions on his nose, swelling and bleeding around both his eyelids, and a 2.5 centimeter laceration with abrasions on the back of his head. She also noted skull fractures and brain injuries, with the brain sent to a neuropathologist for analysis. Additional injuries included superficial abrasions of O'Keefe's chest, right arm, and knee, as well as a rib fracture likely caused by resuscitation efforts. The medical examiner testified that O'Keefe's cause of death was blunt impact injuries to the head with hypothermia as a contributing factor based upon his body temperature of 80.1 degrees Fahrenheit at the hospital. His ethanol level, alcohol, was 0.21 grams per decimeter, with no illicit drugs or prescription medications detected. The doctor could not determine the manner of death to a reasonable degree of medical certainty, and her findings were recorded on O'Keefe's death certificate. Now, during the cross-examination by Mr. Alessi, he pressed the doctor on her conclusions, particularly regarding hypothermia and the absence of grass in O'Keefe's injuries. When asked if she expected grass based on the police's theory, the prosecution objection was sustained. The doctor confirmed she saw no evidence of grass and had not considered alternative causes for O'Keefe's low body temperature, such as sepsis, which she deemed inapplicable. Alessi also inquired about the presence of law enforcement at the morgue, with the doctor confirming that Trooper Michael Proctor had informed her office of the police's working theory. Now, the autopsy photos, according to people in the courtroom, visibly impacted the jurors, with all but one taking extensive notes. O'Keefe's family and friends in the courtroom were emotional, with some crying during the presentation of those images. One juror appeared skeptical during Alessi's questioning about the grass, indicating close scrutiny of the defense line of inquiry. The court took their morning break, and then followed by an immediate sidebar. Testimony resumed with the doctor, and the court recessed for lunch about 1:30 this afternoon. The day's proceedings were marked by frequent sidebars reflecting ongoing legal discussions outside of the jury's presence. Too many sidebars. Question asked, objection stated, judge rules, boom, that's it. Move along. That's the way it's done. To have that many sidebars, I mean, just indecisiveness on everybody's part. This is why we had all these pretrial rulings. I just don't understand why there's so many sidebars in this particular case. Next on the docket, Sean P. Diddy Do It Combs. All right, here we go, ladies and gentlemen. Cross-examination in the sex trafficking and racketeering trial there in New York of Sean Diddy Combs continued this week in the Manhattan Federal Courthouse, where he faces charges of sex trafficking and racketeering. Now, the prosecution's key witness is Combs' former girlfriend and R&B singer Cassie Ventura endured a rigorous cross-examination by Combs' defense attorney, led by attorney Anna Estevao, as the courtroom heard graphic and emotional testimony about the decade-long relationship. Now, Ventura, who is pregnant and nearing her due date, provided detailed accounts of alleged physical and emotional abuse, including a rape she claims occurred when she attempted to end their relationship. She described a controlling dynamic marked by violence and Combs' fixation on orchestrating sexual encounters, which he referred to as freak-offs. These encounters, Ventura testified, involving male sex workers and were meticulously directed by Combs down to the use of large quantities of baby oil to achieve specific aesthetics. The defense, while acknowledging Combs' guilt in domestic violence, firmly denies sex trafficking and racketeering charges, and the cross-examination focused on portraying Ventura's participation in these freak-offs as consensual, presenting text messages and emails from early in their relationship that expressed mutual affection and enthusiasm for these encounters. In one 2017 text, Ventura wrote, "I love our FOs when we both want it," though she later testified that such statements were hollow attempts to appease Combs. The defense attorney also suggested that Ventura's 2023 lawsuit against Combs, which first publicized the freaks-offs, irreparably damaged his career. Now, Combs appeared somewhat relaxed, dressed obviously in civilian clothes, and gave encouraging words to his attorney, saying he was proud in a moment that was caught on a hot mic. The defense highlighted Ventura's past relationship with the music producer Ryan Leslie, noting her history with older men and questioning her about Combs' opioid addiction, which Ventura said exacerbated his violent behavior during withdrawals. Now, the trial obviously is not being televised because it is in federal court, but sketches are being provided. Now, Combs' family, including his mother, Janice, and sons Quincy, Justin, and Christian, have been present throughout the trial, and his daughters were notably absent during Ventura's graphic testimony. The court also heard that Combs occasionally engaged in sexual activities with other women in Ventura's presence, which he framed as part of a swingers lifestyle. Now, the judge has imposed strict deadlines for the defense to conclude Ventura's cross-examination by the end of Friday, which is the 16th, citing her advanced pregnancy. If necessary, Ventura may return for redirect questioning on Monday. The trial is expected to last approximately 8 weeks, and it continues to unravel a complex narrative of power, control, and alleged abuse, with the world watching closely as these details emerge. Next, why do people commit crime on video? It's being recorded, for God's sakes. Everywhere is being recorded. Even in the Uber. That's right. A Florida rapper and a companion distributed a video depicting an Uber driver brandishing a firearm at Chrissy Celeste, an emerging Miami rapper known as Bomb-Ass Chrissy. I know, you probably got it downloading it right now, right? Anyway, she was in a car with her companion following a dispute during a ride. The footage shared by Celeste captures the incident, which she alleges stems from a disagreement over navigation instructions. In the video, the driver is heard shouting, "Get out of my vehicle now," while simultaneously contacting 911, declaring the passenger ride has been terminated. The situation escalated after Celeste remarks that the driver had crazy eyes, prompting the driver to draw a gun and aim it toward the backseat passengers. Celeste, in an interview, expressed her shock and fear during the ordeal, stating she believed she might never see her 4-year-old son again. It escalated so quickly, my focus was entirely on the gun. That's called gun focus, ladies and gentlemen. Anyway, the incident occurred late Monday in Miami and reportedly began when Celeste attempted to guide the driver on a turn. I said, "The turn is right here. You're going to make a left." She was in the middle lane and responded, "You don't have to tell me. That's why I have the GPS." Celeste recounted that she believes her comments about the driver's eyes triggered the aggressive response. Celeste and her companion intended to pursue legal action against Uber. Their attorney described the driver's actions as extremely aggressive, and the act is drawing a firearm is excessive. He stated disagreements, however heated, do not justify pointing a firearm at somebody. This constitutes aggravated assault, and it was captured from the victim's perspective. Uber has confirmed that the driver has removed themselves from the platform pending the investigation, and the company said the situation is extremely concerning and noted the guidelines prohibit drivers from carrying firearms. Let it go, ladies and gentlemen. Let it go. Just get out of the car. Just get out of the car. Next on the docket, this day in legal history. On May 15th, 1928, federal prosecutors were securing convictions in the Teapot Dome scandal involving the bribery of public officials. The case led to reforms in government leasing and anti-corruption laws. On May 15th, 1940, the Department of Justice was preparing cases under the Smith Act, passed in 1940, to criminalize subversive activities. These prosecutions targeted communists, obviously testing First Amendment boundaries. And on May 15th, 1967, the United States Supreme Court ruled in Galt that juveniles accused of crimes have due process rights under the 14th Amendment, including the right to an attorney, which somewhat transformed juvenile justice at the time. And on May 15th, 1976, Congress was implementing amendments to the Federal Election Campaign Act following Buckley v. Vallejo. These changes shaped campaign finance laws and prosecutions for political corruption. And next, the new little series we have every day, a legal quote of the day. It's an Italian proverb. All criminals turn preachers under the gallows. Basically, everybody finds religion when they're in custody. And finally, our dumb criminal of the day. Please meet James Calabas. The 66-year-old Georgia man was arrested Sunday for obscenity after police discovered him pleasuring himself inside a display storage shed at a Lowe's home improvement store in Louisiana. Police responded to the business after getting a 911 call that a naked man was inside one of these small sheds being offered for sale, because that's normal. Anyway, after examining several sheds, the officers discovered Calavas lying on his back on the floor of one of the sheds with his pants at his ankles and an open bottle of Vaseline at his side. I guess he was getting a freak off or something. Anyway, Calavas was in the midst of a personal pleasure session, according to the police reports. He apparently acknowledged that he was pleasuring himself inside the shed while watching YouTube. Needless to say, he has been arrested for obscenity and booked into the city jail. No freak-offs in the Lowe's parking lot where the sheds are for sale, ladies and gentlemen. If you got to do that, do it at home, in the privacy of your own home. All right, that's all we have for today, ladies and gentlemen. Thanks for watching. Have a wonderful day. We'll see you next time. And remember, the Constitution matters.